Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Indigenous rights and mines. Cases that should have gone to the Supreme Court of Canada, but didn't. The Taseko Mines project has been fraught with litigation in British Columbia, and one of the issues that has plagued this litigation has been whether or not the Indigenous groups who had claimed the land where the mine was going to be placed were treated fairly in the Crown's duty to consult and accommodate the interests of the First Nations when approving the mine and when developing the project. Unfortunately, the First Nation unsuccessfully challenged the project on judicial review of the decision to approve the project, arguing that they weren't given procedural fairness in the process that led to the approval designation and the beginning of the construction of the mine. One of the issues that was raised in this case was about the duty of fairness. Anytime an administrative tribunal hears a case or makes a decision in a case, they owe the parties a duty of fairness. This is known as procedural fairness. And procedural fairness can vary based on the type of application that's being brought and the sort of content of the proceeding. But the question in the Taseko Mines case that was ultimately refused leave by the Supreme Court of Canada was whether the duty of procedural fairness can change at various stages of an administrative decision, even though the same decision is being considered by the same body. And we see this in lots of areas of law where there are different stages of dealing with an administrative tribunal to reach an ultimate decision on one very narrow issue, but it goes through various processes in the litigation before the tribunal that may or may not engage different duties of fairness. The Supreme Court of Canada has said very little, generally, about the duty of procedural fairness in administrative hearings and the content of that duty, particularly when it comes to various stages of administrative litigation, and what happens at those stages might impact upon the fairness rights of an individual. This was an opportunity for the Supreme Court of Canada to address these issues of fairness, something that is at the heart of administrative hearings, and something that there is sometimes a perception is eliminated by the administrative hearing process. The Supreme Court of Canada had the opportunity to say, here's how we're going to make hearings more fair, or here's how hearings already are fair, and how that process is meant to be applied. And unfortunately, they didn't take that opportunity at a case that had huge implications for the people involved and the Indigenous community writ large in British Columbia. This is something that the Supreme Court of Canada should clarify, and I hope that another case will be brought to bring the Supreme Court of Canada to the attention of the procedural fairness issue and to have them address it in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.